Court is on the record in the City of Conneaut versus Keith Garvin, 25 CRB 91. On April 7, 2025, Mr. Garvin pled not guilty to one count of domestic violence, a first-degree misdemeanor. We conducted a first pretrial conference on April 14, 2025. This case is set for a second pretrial conference today. In the meantime, on April 29th, 2025, the law director filed with the court a motion to revoke Mr. Garvin's bond. And so the court also, in addition to the pretrial conference today, the court also set this case for a hearing on the motion to revoke. This case was set at 9 a.m. today.
Buckle up, guys. Today we're going to watch a courtroom that starts calm, but turns volatile fast. The judge outlines the case, the charges, and the exact timeline leading up to today's hearing. Everything seems routine until the biggest red flag hits. The defendant was warned, notified, and fully instructed to appear. Yet as the clock ticks past 9:16 a.m., he's nowhere to be found. And that's where the tension begins to rise.
The defendant was given notice of the hearing today. We have a signed receipt in the file show he was given notice at his last pretrial conference. It is now 9:16 a.m. and the defendant, Keith Garvin, has failed to appear. Present in the courtroom is his attorney, Philip Heasley, law director John Lewis, and Officer Pinkett of the Conneaut Police Department. Mr. Heasley, can you advise us to where your client is?
Yes, Your Honor, thank you. My client's whereabouts are currently unknown to me. I will say for the record that notice letter for him to be here today at 9 a.m. with the time and date in bold print did go out to him, and we have not heard from him, Your Honor. And furthermore, as of today, I have been provided with additional discovery regarding the alleged incident regarding the bond revocation hearing. So, unknown, Your Honor, and I'm sorry to say that. Thank you very much.
Have you attempted to reach him this morning?
I have not done that, Your Honor.
I thought you told my bailiff that you attempted to call him this morning.
Not this morning, Your Honor. So, I'm sorry if I indicated that. No, that was.
Do you have a good contact number to call him?
I will check, Your Honor.
You know, Mr. Heasley, if your client, and that happens fairly frequently, when your client fails to appear and you have contact information, you shouldn't have to wait for the court to tell you to call him.
Yes, sir.
I mean, you've been doing this long enough to know to get on the phone and call him even before we go in the courtroom. Don't even worry about it. He's not here. I'm revoking his bond. I'm issuing a warrant for his arrest. No bond will be imposed on that warrant. We'll reschedule anything in this case until...
Right here, the pressure shifts to the attorney, who suddenly has no idea where his client is. He contradicts himself about calling the defendant, and the judge immediately picks up on the inconsistency. As the attorney fumbles through excuses, the judge's patience fades. With the defendant still missing, the judge reaches the breaking point and revokes the bond on the spot, issuing a full arrest warrant.
Until the defendant is incarcerated and the warrant is executed. You know, for the benefit of your client, you may want to do that in the future, but too late now. I'm revoking his bond and issuing a warrant.
And, Your Honor, I don't see a phone number in our contact information for what that's worth. So, on will issue. Thank you. Thank you.
Anything further, Mr. Lewis?
Oh, no, Your Honor, thank you.
Okay. Okay, this matter is concluded. I'm sorry that all the witnesses are inconvenienced. Mr. Garvin, have a seat. Court's back on the record. City of Conneaut versus Keith Garvin, 25 CRB 91. Mr. Garvin comes strolling in at 9:25. a.m. Case is set for 9 a.m. Where you been? Excuse me? Home. Take him into custody, hold him, and then we'll make you think about being on time. Seriously. We're revoking your bond. Tired of people being late. I've got a full docket today. Full docket. You know you're supposed to be here at 9.
Just when the courtroom thinks the hearing is over, the defendant casually strolls in 25 minutes late and gives a one-word answer for his absence. Home. That single response pushes the judge past tolerance. Without hesitation, the judge orders him into custody on the spot. A simple tardiness transforms into immediate consequences as the courtroom watches him taken away to learn a hard lesson about punctuality.
Okay, the court is back on the record in City of Conneaut versus Keith Garvin for the third time. Case number 25, CRB 91. The court instructed Officer Pinkett to bring Mr. Garvin back up from the jail so we can proceed with today's hearing and pretrial conference. Mr. Garvin is present. He's accompanied by his attorney Philip Heasley, also present Law Director John Lewis, and Officer Pinkett sitting at the Law Director table. Mr. Garvin, does your attorney know how to get a hold of you? You left him 4 different voicemails? Does he have your phone number? Write your phone number down. You got it?
Yes, sir.
Okay, that's good. Because earlier, a few minutes ago, Mr. Heasley reported he did not have contact information for you. So, when did you leave these 4 voicemail messages?
I believe the first one was the day after court.
Do you guys even have voicemail at the public defender's office?
We have voicemail, Your Honor.
I'm not even going to get into that.
Okay.
You know, if this is true, because now I'm really steaming. Why were you late today?
The defendant is brought back from jail, and now the confusion deepens. He claims he left multiple voicemails for his attorney, but the attorney insists he had no contact information for him whatsoever. The judge listens, unimpressed, and highlights the communication breakdown between both sides. When asked why he showed up late, the defendant insists he thought he was early, setting the stage for an even sharper confrontation.
Yeah, well, I've got a signed receipt in the file showing that you signed a receipt with a 9 o'clock a.m. hearing date, or hearing time. So, you were wrong that it started at 10. Okay, counsel, have you guys talked about possible resolution, or are you ready to proceed with the hearing on motion?
I'm ready to proceed, Your Honor.
Okay. Mr. Heasley.
Thank you, Your Honor. We have just been provided with information regarding the revocation
What do you mean just provided?
earlier this morning from the prosecutor, Your Honor.
Well, you knew this hearing. You knew today was also scheduled for a hearing on the revocation, though,
Yes,
right?
sir.
Okay. So you're talking about like discovery information?
This is on an alleged incident from April 20th.
When I ask you what were you provided today with, is it discovery information about the revocation issue?
Yes, sir.
Okay. So what are you asking?
And I do realize the court has its schedule a minute or two to speak with Mr. Garvin regarding the revocation and whether he would admit to the same. And if not, we're prepared to have a hearing. Thank you.
Okay, go ahead. Take a few minutes.
Thank you,
You
sir.
know the court's schedule today.
Yes,
I mean,
sir.
we are stacked. We're going to
Yes,
be
sir.
here until 5 o'clock tonight. So.
The judge presses the defense for answers, and the attorney reveals he just received new discovery that morning. The judge immediately challenges this, pointing out that the hearing was clearly scheduled. As the courtroom grows more tense, the judge grants the attorney a brief moment to speak privately with his client about the bond revocation. The pause only heightens the sense of what's about to unfold next.
On the record, the City of Conneaut versus Keith Garvin, 25 CRB 91. Mr. Heasley, have you and your client had an opportunity to discuss this matter?
We have, Your Honor. He wishes a hearing on the revocation of bond. Thank you.
Okay, thank you. Any opening statements, counsel?
No, Your Honor.
Wait, opening.
Okay, call your first witness, Mr. Lewis.
City would call Officer Dan Pinkett. Are you a certified peace officer in the state of Ohio?
I am.
I want to draw your attention to April 28th, 2025. Were you on duty that day?
Yes, sir.
And did you have any interaction with the defendant, Keith Garvin?
Yes, sir.
Okay, and how to tell the court, please, how that interaction transpired?
Sure. I returned to the Conneaut Police Department to meet with a male subject identified as Mr. Garvin in the front lobby of the police department. Mr. Garvin proceeded to tell me that while in the vehicle with the mother of his child, Tony Martini, that she struck him several times in the face while they were going to get dog food.
Did that allegedly happen on April 28th?
Yes.
In the city of Conneaut?
Yes.
He was in the vehicle with the alleged domestic violence victim, Tony Martini.
That's correct. Or he was being the victim in this case.
Told you?
Yes, sir.
Okay. What if any...
With the break over, the hearing officially begins. The prosecution calls the responding officer, who recounts meeting the defendant at the police station. The defendant claimed he was punched multiple times by the alleged victim while they were in a car together, raising new layers of complexity. What seemed like a simple bond violation now mixes with claims of violence, and the courtroom begins unraveling deeper details.
Anything else did Mr. Garvin tell you?
That while they were going to get dog food, he called his friend to go lock his front door. Mr. Garvin advised me that upset Miss Martini, and she became enraged and punched him approximately, if I do recall correctly, 4 times in the face.
Did you at any time take a written statement from Mr. Garvin?
Yeah, that day, yes, sir. Yes, sir.
That's a written statement that Mr. Garvin provided to you on April 28th.
Correct.
Would you please read that for the court?
Sure. Tony Martini picked me up to get dog food. Then I called my neighbor to lock my door. That's when she lost it and punched me 4 times. She busted my lip, my neck, and jaw is swollen. So I called my friend to take me to the police station. And file this report. I'm sorry.
Is that signed by Mr. Garvin?
Yes, sir.
Did you witness him sign it?
Yes, sir.
I'm going to approach again, Your Honor, and did you obtain any other evidence in the case?
Yeah, I spoke to Miss Martini afterward.
Okay. And did she provide a written statement?
She did.
Okay. Did she provide anything else to you?
Yeah, she showed me a picture of emails from Mr. Garvin to her on her phone.
I'm going to approach the witness again, Your Honor.
Okay.
Do you recognize that photograph, sir?
Yes, sir.
And did you take that photograph?
I did, yes, sir.
What's depicted in the photograph?
It's emails from Keith Garvin to Miss Martini saying, hurry up. She says in the shower. He says, pull up real quick. And he says, the door go be unlocked. I don't even want to answer anymore. And it's from Keith Garvin. You can see it.
So the emails say that they're from Mr. Garvin?
On April 28th, that's correct.
The emails are dated April 28th?
Yeah,
And you took that photograph?
I did.
Appears to be a true and accurate copy of the photograph you took?
Yes, sir.
How about the statement? Does that appear to be a true and accurate copy of the written statement that Mr. Garvin gave you?
Yes, sir.
Thank you, Officer Pinkett. I have no further questions at this time, Your Honor.
Thank you. Cross-examination.
Thank you, Judge. Officer Pinkett,
The officer reads the defendant's written statement, describing facial injuries and the events leading up to the report. Then powerful evidence surfaces. Email exchanges captured directly from the alleged victim's phone, showing clear communication between both parties on the same day. These emails contradict the no-contact order and reinforce the prosecution's argument, turning the courtroom's focus sharply toward a potential violation.